will you be able to enter it at arm's length in good faith? Probably not. Power balance is too uneven, so good call, Bussy. Release the contract. Hi there, my name's Leach. I'm a real-life lawyer on a mission to demystify the law and how it affects your everyday life. Today I'm going to do something a little bit different. I came across this video on the YouTubes, and it's called Exposing the RuPaul's Drag Race Contract. I don't know who this guy is. His name is Bussy Queen? Busy Queen? I don't know. Anyway, and I wanted to just see what it says and what he says about it. He says he's not a lawyer, and I am. So let's talk about it. So I've not watched this video yet, and I also have to make a confession, and that is that I have not ever watched RuPaul's Drag Race. I know that makes me a bad ally, I understand. And as someone who considers themselves a part of the queer community, I think it is a cardinal sin. And I recognize that, and I'm sorry. I love Trixie Mattel because I live in YouTube land and can't escape, and I think she's really funny. And so I'm not like 100% clueless, but I'm like 98% clueless. But I've studied the law, so hopefully I can help there. Okay, let's watch. Oh, and before we get started, let me say that I'm a lawyer, but I'm not your lawyer. Nothing that I say should be construed as legal advice. You should always seek the advice of a licensed attorney before making any legal decisions. Hi, ugly.
It's me, Bussy.
Did he just call me ugly?
I was able to locate a copy of this form, which, as it turns out, is made public to anybody who completes the first part of the RuPaul's Drag Race casting process, and I read every word, so you don't have to, in hopes of dispelling the rumor that going on Drag Race is all rainbows and sunshine.
All right, let me see this. Did he link to this contract? Where's the actual contract that he's talking about? Yeah, you're talking about the season 14 contract. Where's that? You didn't link to that. Let me see. Now I have to be Nancy Drew and find this contract. Let's see what I can do. RuPaul Drag Race Season 14 contract. Oh, you've got a whole Reddit thread? Good for you. Okay, everyone is referring to Bussy as she, so I apologize if I am misgendering. Where'd you get the contract?
I was able to locate a copy of this form, which, as it turns out, is made public to anybody who completes the first part of the RuPaul's Drag Race casting process.
Made public to anybody who completes the first part of the RuPaul's Drag Race casting process.
Bussy Queen, you got some splaining to do, because I don't know where you got this contract, and neither does Reddit, and Reddit knows everything, so...
Made public to anybody who completes the first part of the RuPaul's Drag Race casting process.
I really would like to read the whole thing. It's not in the comments. This is very interesting, Bussy. I would like you to release the contract. Release the contract!
And the next part signs away your rights to all of the materials in the show, including the casting tape that you created and submitted to them.
That is interesting, because if you've watched any of my videos about copyright law, you know that the minute that you film something, you make something, you own the copyrights in it. This is what's so important about reading contracts really carefully, because you can sign away pretty much any of your rights unless it's like completely unconscionable, and even if it is an unconscionable contract, in order to get out from under it, you would have to go before a judge and go through the process of a lawsuit in order to have a judge say this contract is unconscionable and therefore not enforceable, and therefore you don't have to participate in it or perform under the contract. So when you film your casting tape for RuPaul's Drag Race, it is your property. That tape is yours. You own all the copyrights to it immediately. However, if you sign this, you're signing away those copyrights. I don't know what presentation means. The materials of the project, including but not limited to any casting tape, presentation, and or the series. I would like to know what presentation means. Like, is that going to include a presentation of her act? Is it going to include presentation of the show itself? What does presentation mean? This is the thing with contracts, is every single word matters, and so then deciphering it is hard. Usually there's a definitions section of a contract so that you can see kind of what the words mean. However, usually words that have been defined in the definitions section of a contract are capitalized. So for instance, in this project, the word project is capitalized, which tells me that there is a definitions section somewhere in this contract that has defined what project means. However, presentation is not capitalized. Series is capitalized, so we probably have been given a definition of what series means, but presentation does not. So you're signing over all your rights to your casting tape, which makes sense, and in the series itself, which also makes sense, but then also this kind of weird presentation word, we don't really know what that means. Again, when you have an issue like this where a contract is being enforced against you, where the words are ambiguous or they don't have a definition in the contract, that's where you can kind of push back on the contract itself and say, well, that doesn't actually mean what they say it means. What it actually means and what we entered the contract understanding it to mean is X instead of their definition Y. However, in order to get this type of interpretation of the contract enforced, again, you have to go through a lawsuit. You know what lawsuits are? Really freaking expensive. So again, this is why contracts matter so much, because even if something's wrong with the contract, even if the interpretation is off, you're signing it with a huge conglomerate like RuPaul's Drag Race, and you're just a little guy, you're just someone who's trying to make it. And even if you have made it, you're still one person against a whole conglomerate of people in a whole company. Fighting that amount of resources, like they can hire the best law firms that will hire the best attorneys, and they can spend hundreds of thousands of dollars to kind of drag out the litigation until you just give up. There's real consequences to it. So you gotta read what you're signing away. However, I will say that signing away something like your casting tape, if you are sending it in, seems like pretty reasonable. It's reasonable of RuPaul's Drag Race to have written that into the contract, because I don't know, sometimes you see casting tapes from like old movies or something and you see an actor and there's like value in that. Like there's value in seeing an old casting tape from some famous actor years later. Similarly, I think there's value in seeing a casting tape from a contestant who then later goes on and makes it in RuPaul and has a longer career, etc. Like there's value in that intellectual property, frankly. So it makes sense for them to want to try to grab onto that. Interestingly, the amount of value that it would have if you sign it over to them in exchange for being on RuPaul and then you make it on RuPaul is greater than if you were to say, no, this is my copyright, my intellectual property rights, because then you wouldn't be able to go on the show, make it big, and then add value to something like your casting tape. Does that make sense? It's a value proposition here, and you have to make the choice of what you're willing to give up in order to get the exposure that RuPaul's Drag Race offers.
It says that the producer may exercise any of the additional series options no later than the date that is 4 years after the initial exhibition of the final episode in the immediately preceding cycle. This means for up to 4 years after the finale of the season that you most recently appeared in, the producers can call you back at any time and let you know that they would like you to appear in a future season.
So basically what this means is that the producer can call you, like Bussy already explained, the producer can call you within 4 years of the last episode of the last cycle that you were on and say to you have to come on here. If you say no, they could sue you for breaching this contract. And I bet there's a provision in the contract that says how much they could sue you for, and maybe we'll get to that in this really long video that I am only 3 minutes into. Okay. I will note though, it says that it has to be via written notice. I'm sure they have a whole legal team that has this all set up in like a very systematic matter, but I would say that is a door to, if they called you and expected you to show up but didn't provide you with written notice, you could get out from under it. But then you would just say, hey, you didn't give me written notice, so I'm not going to appear, and then they would just give you written notice. So it seems pretty tightly written there.
They could just say no if they got the call, right? You can't force somebody to get into drag and compete on All Stars, can you? Well, we're going to save that topic for the section of this video when I discuss what happens when you withdraw from the project, are terminated, or otherwise breach your contract. During the production of this season, they want you to assist in, let's say, the creation of a mobile game in which your likeness, catchphrases, and pictures are going to be used. Guess what, Mimi? You're contractually obligated to participate.
So this is really interesting, and it's an important thing to note because if someone uses your likeness without your permission, especially for commercial purposes, that's something that you can sue them over. Like, that is what's called a tort, which is a funny word that we call anything that where someone has wronged you and you sue them in civil court to be made whole again. It's not necessarily, most of the time, going to be a crime, but it is something that is your right not to have happened to you, and if it does, then you have the right to sue the person who does it. So, for example, this happens sometimes with celebrities. I can't remember who it was. It was some white blonde lady celebrity. She was leaving a drugstore just like laden with a bunch of bags trying to do her errands. A paparazzi took a picture of her, and then that drugstore, I can't remember which it was, was, Walgreens, CVS, one of those, took that picture of her kind of like trudging around with the bags, put it on their Instagram saying like, even she shops here. She turned around and sued them because they were using her image without her permission to sell stuff, and she won. So it's very important that this be in the contract so that RuPaul's Drag Race can have full control over the content that they are producing by filming all of these drag queens when they're not, on stage.
If from the effective date, the agreement, until 24 months after the initial broadcast of the last episode of the program, I desire to render services in connection with another television program or motion picture, internet production, or other audiovisual production, I will negotiate for 30 days with the producer. It goes on to say that the producer has the exclusive right to accept or deny any offers you receive. So let's say your exclusivity period technically ends. We're a year after your last appearance in the show. Well, they can actually still have complete and total control of any other media projects you could potentially appear in for up to 2 years after the last episode of the season.
Okay, first of all, Bussy, have you ever considered law school? Because you get it. Contract interpretation sucks and is super boring, but you figured it out, so good on you. So this is really interesting to me. This reminds me a lot of the types of clauses that are often in employment contracts that you sign when you start a job that says, if you leave, you cannot work at any of our competitors for X number of months. This is super, super common. Doesn't surprise me that it's in here. However, there are tons and tons of cases where former employees bring a contract like this in front of a judge and say that it's unconscionable because it is way too geographically wide and or way too long of a period. So if you work for a tech company in Minneapolis, for example, and you sign a contract that says you are not allowed to work anywhere else that we compete with in any of the United States for 3 years, you could probably have a solid case if you brought it before a judge to say this contract's unconscionable and shouldn't be enforced, and therefore I should be able to work wherever I want. I'm not an expert in employment law by any means, but I would say you'd have a pretty good argument if you brought this before a judge and said, I am completely beholden to this company for an extensive period of time over all social media, any tour I want to do. There doesn't seem to be any sort of geographic limitation to that clause in the contract, and so companies, employers are not allowed to restrict your ability to work elsewhere for that long. It's allowed to a certain extent, and that makes sense because we're trying to balance the business objectives of a company that's hiring you versus your objectives as an employee. And so we want to give businesses some sort of ability to say, you can't come here, take all the skills, use us to learn, and then go immediately to a place next door that's a competitor of ours, because it could lead to sharing of trade secrets. There's viable reasons why a company would want that, but there is a point where we believe in free market movement of employees and people who are able to work, especially skilled labor that wants to move around and use their skills in other companies that are potential competitors of the companies that they've worked for in the past. I mean, it would be unreasonable if a very specific type of engineer works at one company and then for 3 years can never work at its competitors, because if you're specialized and you're highly technical, and I would say being a drag queen is a specialized, highly technical form of labor, you should be allowed to go places and do your labor that you have learned and spent your time specializing and perfecting without having to worry about this clause in a contract keeping you from being able to work for years on end.
You're actually signing to receive management from World of Wonder under contract terms that you do not know. It literally says your split rate is to be negotiated in good faith between the producer and you in accordance with industry standard. So they require you... Sorry, this is so ridiculous. So they require you to be managed by them at a rate which will be negotiated later based on good faith, under the circumstance, of course, that you have no leveraging or bargaining power at the point at which they will negotiate said rate.
Again, Bussy, have you gone to law school already? You're hitting the nail right on the head. This is another huge contract issue. If the balance of power is so out of whack in a contract negotiation that one side holds all of the bargaining power, then if you brought it before a court of law, they might say that it is not enforceable because it's unconscionable to be able to exercise that level of control and leverage over someone. And here it does seem, I mean, again, I don't have the full contract in front of me. Bussy, drop the contract. Let me see it. But I would guess that Bussy's right, because it does kind of seem like you're already agreeing to do something that you're bound to already, and then you can't actually negotiate any part of it. Seems sketchy. Seems like at least during that later negotiation process, if you didn't get what you want, you might have a viable argument before a court to say, I didn't get what I want, and this later contract is not enforceable because this other contract that I'm bound by means that I didn't have any leveraging power in this negotiation, and therefore they had undue influence over me, and this is not enforceable. And that good faith line, I mean, it's really typical in contracts. There has to be arm's length, good faith negotiations when it comes to a contract. If that doesn't happen, then the contract often is not enforceable. So they're saying good faith because they're saying like, oh, well, we're going to go negotiate and it's going to be an enforceable contract later, but you are kind of agreeing to be bound by this thing in the future that you don't really know what it's going to be. Will you be able to enter it at arm's length and good faith? Probably not. Power balance is too uneven, so good call, Bussy.
What is the industry standard? And what industry are we even talking about here? Drag, TV production, Hollywood in general?
Bussy, you're blowing my socks off. You're right. This is exactly, that's thinking like a lawyer. What do these words mean? It's all about interpretation. It's all about definition. If you don't know what they mean, then they're open to interpretation later and you might be bound by it. So careful.
Which, by the way, are not only granted to World of Wonder, but also the Viacom Media Network in general and all of their respective licensees, designees, and successors. Perpetually, irrevocably, and for... I wish I was making this part up. The exclusive use and enjoyment throughout the universe. And I hereby grant the producer to use and or license my likeness and my name for the purpose of and in connection with the sale of third-party products, goods, and services.
This hits on the same thing I was just talking about. Your likeness is very valuable, especially if you have an element of celebrity. Being able to put your face on things, your name on things, is a huge business. There are many people who get trademark registrations in their name. I don't think you can register a likeness for a trademark. That'd be an interesting question. But the reason why they apply for these trademark registrations is because the value that you have in your own name, especially when it has a certain amount of clout, is huge. The amount of money in IP is insane. The amount of money, for example, in Nike the brand, huge. You slap a Nike symbol on any product and it's going to come with the whole reputation that Nike has spent God knows how many decades and millions of billions of dollars building. So if you're on Drag Race, you've probably had a long history before getting to Drag Race of your experience being a drag queen, and then you're on the show, you're building more experience, you're building your brand, you're building your identity as a performer, and then you're signing that away to them forever. Now, it doesn't sound like they're being granted exclusive use. That would be insane if it was like, not only can we use it anywhere in the universe forever, but you can't use it anywhere else. That's where that exclusivity provision comes in. The exclusivity provision means that it's only for that certain amount of period of time that they can control your likeness, but the fact that they can use and profit off your likeness and you can't stop them ever is huge.
Would only be contractually entitled to be paid $639 per episode by the time they appeared in their sixth season in 2042. And by the way, money is worth less and less every single year due to a monetary concept called inflation. So that $639 20 years from now would be worth 430 of today's dollars.
Bussy, I was literally just gonna say that with inflation, it doesn't make any sense. Nailing it. Really smart.
But there is also, of course, the possibility of winning the season and earning a $100,000 cash prize.
I'm sorry. If you win Drag Race, you only get $100,000. It's 2021. Like, that's not that much money. I mean, it's a lot of money. $100,000. I mean, I would get if it's $100,000 and then also you're famous and can kind of go off and build your career from there. But based on the terms of this contract, it sounds like you're given $100,000 in exchange for them getting to profit off of all the fame that you've garnered. Yikes.
RuPaul, on the other hand, as reported by TV Guide back during the production of season 5, was earning $50,000 per episode.
That's capitalism, baby.
Even if one of the queens makes it halfway through the season and takes home, I don't know, $4,000, that's nothing compared to, what, the 3 months that they spent preparing for this season, the 2 months they spent filming it, and all of the things they had to give up to appear on the show, including wardrobe expenses, which likely eat up that $4,000.
Wait, so when you're on Drag Race, you have to buy your own clothes? If that's true, that's wild. $500 an episode, and you look at some of those costumes and the makeup. I could go to Sephora right now and spend $500 $500 on like 3 things. I wonder if you could argue that that's unconscionable, because the expectations of the job and the expenses and the time and everything in exchange for that amount of money is insane. However, I will say, when you sign an employment contract or any sort of contract really, if you are agreeing to the terms, as long as you've entered into the contract knowingly, a judge isn't going to look at the weight of each person's performance. Meaning, the judge isn't going to say, well, you only paid them this amount of money and in exchange they did all of this stuff. The idea being you get the benefit of your bargain. So as long as you go into the contract knowing what you're signing up for, the judge isn't going to say whether or not the amounts on each side are equal or not. So it's possible that there's no recourse for that, even though it seems absolutely insane. I also wonder whether the contract says if they are considered employees or independent contractors. I'd imagine they're independent contractors, because I can't really see a reality show contestant being an employee, meaning all that money that they're making, they have to then go and pay taxes on top of, and that's not cheap. Anyone who makes 1099 income or does any sort of gig work knows that like you have to save at least 1/3 of what you're making in order to pay the taxes later. So like take that, but then minus 1/3 of it, and that's rough.
But you do agree to a liquidated damages cost for breaking the NDA, listed at $2 million, which, by the way, is clarified to not be a penalty, but simply an agreed upon sum between 2 consenting parties.
So the reason why they included that provision in there is because under contract law, you can't get penalty damages. So you can't sue someone for breaching a contract and ask the court to award above and beyond what is warranted under the contract. So saying that that's not a penalty, it's just 2 people entering a contract, understanding what they're signing up for, is protecting them from the court saying that it's a type of penal damages that they're asking for. That being said, though, I mean, if you were on the other side of this NDA trying to defend yourself from having to comply with it, I still think you might be able to make an argument saying that that amount of damages, even though the contract says it's not a penalty, still amounts to a penalty, especially given how little that they are paid, generally speaking. Like, that's the biggest number I've heard in this whole video.
Lawyers have speculated it would be impossible for a company to actually win an NDA lawsuit, basically because they would have to prove damages against them, which would be extremely difficult.
Okay, I will say, for a breach of contract claim, which is what this would be, maybe I'm wrong, I'm not sure what Bussy's sources are, but the damage is the contract breach itself. So if you've signed the NDA and then you speak, that's the damage. You don't have to necessarily prove a specific amount. But that goes to my earlier point that $2 million is way beyond any sort of damages that they would experience if this breach occurred, meaning that a court would interpret it as being a penalty, which is not allowed under contract law.
And the period of time where they hold restriction on your appearance in any media is, I think, a little too long.
You hit the nail on the head, Bussy. It seems unconscionable to me, and that would not fly under any employment contract. There is actually case law where it was 3 years that an employment contract said that they could not work for a competitor, and that was just working for a competitor, not your entire existence on social media, and that was found to be unconscionable. So this seems potentially unenforceable. So this has been really interesting. It really seems to me as though RuPaul kind of has a corner on the drag race market, meaning if you ever want to turn your passion of being a drag queen into your full-time job, as Bussy said, you have to be on this show. So there's an issue with monopoly here as well. We don't like monopolies in this country because we love competition, and this competition has wiped out all the other competition, meaning that there's no way for you to get to the level of Trixie Mattel fame without being on this show. I'd say that's another argument in favor of unconscionability of this contract. What do you think? Comment below. Thanks so much, Bussy, for sharing this. I mean, I really think you got a future in law if you ever want to go in that direction. It doesn't seem as fun as being a drag queen, so maybe don't. But, you know, thanks for sharing, and thanks to everyone for watching. If there's some other video on the YouTube universe that you'd like me to watch and react to, please comment below. Don't forget to like and subscribe. Have a good day. Goodbye.